Welcome to today's webinar brought to you by Synergy Settlement Services. My name is Jason Lazarus, Chief Executive Officer and founder of Synergy. The webinar today is Protecting the Recovery, Preservation of Needs-Based Benefits. It will give you helpful insights about the complicated issues around public benefit preservation. We will dive deep into the important government benefits and crucial tools like special needs trusts, giving you important information to make sure your client's SSI and Medicaid benefits are safeguarded at settlement. We'll also touch on the complex issues of dual eligibility, spend down, deeming, and more. So let's get right into it. So before we talk specifically about the government benefits, I wanted to talk a little bit about the ethics around failure to advise an injury victim about preservation of needs-based government benefits. So the starting point is a question as to whether there is an obligation to advise the client related to public benefit preservation. And I think the answer is a definitive yes. There are laws that impact their government benefits, which need to be explained to them. 42 USC 1396 PD4 are the provisions related to special needs trusts and continued eligibility for Medicaid and SSI. And then also the Medicare Secondary Payer Act, even though I'm not going to talk a whole lot about that today, it's important to keep that in the back of your mind that there's also an obligation to explain the impacts of that law to an injury victim when they settle their case. And also there is an important concept called constructive receipt, which is a tax doctrine, which has got to do with when potentially you could trigger a loss of options for the client by taking receipt of the money. There are some cases out there, the Grillo case, French and Saunders cases. Those are all cases where personal injury lawyers were sued for failing to advise clients about these issues. So there certainly are cases out there where personal injury victims have brought suit against their personal injury counsel for failing to advise about this. And if you look at the model rules of professional conduct 1.0E and 2.1, you've got an obligation to make sure that you adequately communicate information and explain risks and alternatives to a proposed course of conduct for a client under 1.0E, and 2.1, where you need to consult with experts in another field so that you can provide competent representation, you should do so. The quote from the article by Bernard Crooks, I think, is a really good one, which is make sure as a personal injury attorney that your client is informed about the options of structured settlements, which isn't the subject of today's presentation, but also trust and the effect of a settlement on a client's public benefits. And also, you've got to make sure that the client's interests are best served, and that could be considering tax implications as the ABA ethical guidelines for settlement negotiations outline. All of that taken together, I think really sets up this duty for trial lawyers, which is to make sure that laws that impact settlement are explained to the client, because if that's not done, there's no opportunity to make an informed decision, and there's no opportunity to exercise options available under the law, which consequently can lead to damages. And the cases that I talked about, including Grillo, is I think tell you that you've got to make sure you are employing or consulting with competent experts in government benefits, trust, taxation, and settlement planning prior to resolution. Because if your law firm does not address these issues, who will, given that they are legal questions and legal issues that need to be explained to the client? And it can be a very small settlement that triggers these obligations, because we're talking about situations where government benefits like SSI have an asset cap of $2,000. So anything in excess of $2,000 could destroy eligibility for an injury victim. So really all cases are going to require the personal injury attorney to explain matters sufficiently for an injury victim to understand the decisions they need to make. Okay, with that, let's get into the government benefits and talk about the different benefits and understand, hopefully the difference between the different types of government benefits. So what you've got are either entitlements or means tested. And it's an important distinction because the means tested are the ones that really are ones that should be of paramount concern because those are income and asset sensitive. You've got to take action for the client's government benefits to be preserved at settlement, or they have to ultimately be informed to take action. And these programs are generally administered by either federal or state or local agencies or both. And there's no one size fit all solution here. So you've got to understand the differences between the benefits and understand what your client is receiving to adequately make sure that they get the right counseling on what to do. So broad categories for needs-based and income asset sensitive government benefits are SSI, which is supplemental security income, which we'll talk a little bit about in greater detail here in a moment. Medicaid for adults, which is disability based, and Medicaid for children, which can be family related, non-disability, but can also be disability related if they're a disabled child. Then the entitlements are SSDI and Medicare. And so on this chart, it gives you kind of a broad overview and also gives you whether it's asset and income sensitive or not, and what type of planning solutions also should be considered, as well as the lien issues related to those. So handy little chart. If you want a copy of the presentation, just email me and I'll give you my contact information at the end, and you can print that out, put it on your desk, save it as a PDF on your desktop. But it's good to look at this information to have a quick glance at the different benefits. Okay, so let's talk about the entitlements first. So SSDI, or Social Security Disability, is a federally administered program by the Social Security Administration. The monthly check is going to range from $800 to $1,800 a month. To get SSDI, you have to be disabled and have paid enough into the system, have enough work credits through your FICA taxes to be eligible. And typically, if someone is on SSDI, they're either already a Medicare beneficiary or will be within 30 months, because 24 months is the time frame from the time that the disability payments begin until you get Medicare eligibility. And there's a 6-month elimination period, which is what gives you the 30 months. And as this is an entitlement, that means that it's not income or asset sensitive. You get it as long as you paid into the system and become disabled. It's important to understand that connection between SSDI and Medicare. Medicare is, as everybody knows, made up of several different parts. Part A and Part B are hospital and outpatient coverage. Part D is prescription. Medicare Advantage rolls A, B, and D into one singular coverage with a private plan that is administering Medicare dollars. In order to be eligible for Medicare, either you have to be age 65 or disabled on SSDI or end-stage renal disease. And again, this is an entitlement, but with Medicare, and it's beyond the scope of today's presentation, you do have to consider whether a Medicare set-aside makes sense. And typically, it's not so much whether a Medicare set-aside makes sense, it's doing the legal analysis as to why or whether anything should be set aside at all, because in many cases, there's arguments why nothing should be set aside. But if someone is on Medicare, they should at least be educated about these issues. But today's presentation is going to focus more on these needs-based government benefits, which are means tested. So SSI, which is supplemental security income, is also a federally administered program by the Social Security Administration. The monthly check amount, which is a quick way to usually see if it's SSI versus SSDI, because the SSI checks are going to be smaller, is a maximum of $914 per month if someone is single, or $13.71 for a married couple. And this amount is supposed to cover basic needs like food and shelter. It's a very small amount of money. For someone to get SSI, they either have to be 65 or older, blind or disabled, and have limited income and resources. So there's an income cap and a resource cap. The resource cap is $2,000 if you're single, $3,000 if you're married. So a very small settlement could trigger the loss of these benefits because of that asset cap. And typically speaking, everything is countable. Income, a settlement would be countable. So unless there's some reason to exempt it, it is going to be countable. Some examples of things that are not countable for the asset cap, the resource test, are your house, one vehicle, and household goods within the home itself. And SSI typically is going to bring with it Medicaid coverage. So it's important to understand that the financial eligibility component of this is what becomes very important in the context of personal injury settlements, and understanding the connection between SSI and Medicaid is important too, because preserving SSI in many instances is necessary to keep Medicaid coverage in place. And Medicaid is administered at the state level, but federal dollars funding it to some extent. It's basic health insurance coverage for the indigent. Qualify, it's going to vary state to state. There are medically needy programs. There are the programs that are based on resources and income. In many states, $1 of SSI automatically gives someone Medicaid coverage. So, and we'll talk about that in a little more detail, why that becomes important later on. So, in summary, you've got these two different columns: the entitlements, which are not going to be lost simply because of you have too much in the way of resources. Medicare isn't a resource test. It's simply a question of whether future medicals are funded by the settlement. And if they are, that's when the Medicare set-aside issue should be addressed. The means test of benefits are SSI, as well as Section 8, housing, food, SNAP programs, VA pensions, and then the Medicaid benefits, which, those are on that right-hand column, are the ones that you've got to worry about when you settle a personal injury case, because they are going to be impacted the day that person receives the settlement monies. So let's talk about the disability planning reasons behind these, the need to address these issues. So the initial question is, why do you need to plan for a personal injury victim who is disabled? One is to preserve those government benefits, because that provides for the rest of their lives, if they're permanently disabled, financial support and medical coverage. Typically, settlements are not sufficient to pay for all of those expenses. It is rare to see a settlement cover all the needs in a life care plan, for example. So having that supplemental financial support from the government along with the settlement creates a scenario where that person is better off than without those government benefits in place. The planning creates a system of advocacy for that client, and it helps to preserve their basic rights. And ultimately, you're establishing a knowledgeable and long-term management team by creating some of these planning solutions for the injury victim. And not every client who is disabled will require planning. It's only those that are severely disabled and meet the definition of disability for government benefit programs that are going to require planning. And those typically are SSI and Medicaid recipients, Medicare beneficiaries, and those who are dual eligible, which we'll touch on as well. So that means they're on Medicaid and Medicare. One of the key things to keep in mind in the disability planning context is this acronym of READ. And this acronym came from one of my colleagues here at Synergy. It's an easy way to remember what you need to do if you're a trial lawyer in your practices to make sure that these issues aren't missed. One is at intake, making sure you review what that client is eligible for uh, and keep updating that throughout the case and really hone in on it when you settle the case. Make sure you enlist the right experts to educate you and your client on the issues. Award letters are incredibly important. Seeing what that client is receiving with your own eyes based on the award letters helps you to make sure that your client isn't confused about what they're receiving. Oftentimes, SSDI and SSI are confused, Medicaid and Medicare are confused. The benefits are coming from similar agencies. So you really want to make sure that you lay eyes on the award letters. And then also making sure you document your file regarding what your client decides to do once the case resolves, if they're eligible for some of these benefits. And that's really important if they decide that they don't want to keep their government benefits, which frequently clients will decide that they no longer want to be on these government benefits once the case is settled. Okay, so let's talk about the needs-based benefit planning tools for preservation of Medicaid and SSI. This is where most frequently we see the issues arise. These are complex issues. As I said earlier, it's really important to remember that $1 of SSI is going to equal Medicaid coverage in most states. That means that you probably want to make sure that some amount of SSI is preserved so the client doesn't simultaneously lose their Medicaid coverage, because oftentimes the SSI payment is small enough to where the injury victim says, you know what, I don't care about losing that benefit, but they don't understand simultaneously they'll lose their Medicaid and then they would have to apply directly for Medicaid. So, most often it makes more sense to set up a special needs trust if they're on Medicaid and SSI and are disabled, because the settlement monies in the month of receipt is income. And then the very next month, it's an available resource if it's not spent down. So these impacts are going to be felt if no planning is done, because the settlement money is not exempted from being counted as income or an available resource after the case is resolved. So there are a couple of types of different special needs trusts that can be set up to make sure that a client doesn't lose eligibility for their needs-based government benefits. The first is a standalone special needs trust, a D4A. That can be created for anyone that's disabled under the age of 65. The next one is a D4C pool trust, which can be created for anyone of any age as long as they're disabled. The only caveat to that is that some states do apply a transfer penalty for those over the age of 65 that put money into a pool trust. So you have to understand the state rules as it relates to transfers for those over 65, but there is no restriction on age under the federal statute for contributing to this particular trust. And then third-party special needs trusts, which are set up in instances where, for example, a fundraiser was done, a GoFundMe, and there's money there that's not the personal injury settlement. That money can go into a third-party trust, or say mom and dad want to do something for their disabled child with monies that they're receiving from a consortium claim, for example. That money could be in a third-party special needs trust. The reason that you set up a third party versus a standalone is the third party trusts are not subject to payback, which I'll talk about in a second, at death. Okay, so what are the advantages of setting up a special needs trust and a personal injury settlement? Well, it keeps the client eligible for SSI and Medicaid. You typically will have a professional trustee in place that can make sure that the settlement monies are managed appropriately. It can avoid a guardianship and annual reporting requirements. and that trust can pay for everything except food and shelter, assuming they're on SSI. SSI is supposed to cover food and shelter expenses. So if the special needs trust pays for food and shelter, then the client will have a reduction in their government benefits anyway. So it doesn't make sense. So what are the disadvantages of using a special needs trust? Well, you don't have unrestricted use of the money. You have a trustee that says yes or no. There is a sole benefit requirement, which means that the trust monies can only be used for the injury victim. They can't pay family expenses or to support other members of the household. At death, Medicaid must be paid back. So for a D4A or D4C, which is a first party special needs trust, those must under federal law have a payback provision, which says at death, Medicaid gets what's left over in the trust to pay back for any monies they've expended during lifetime. That's separate and distinct from any lien they may have asserted at settlement and applies if you set up a special needs trust that's first party. The only exception is that third party trust, because those are assets that are not the injury victims. That's why you set up that third party. And these trusts are irrevocable, so you can't undo it. That's a requirement under the federal code. So those are the disadvantages. One other issue to be aware of with special needs trust is deeming. And this happens between parent and minor child and husband and wife. And what this means is, say you've got a personal injury case that involves a minor child where they were injured at birth, mom and dad have a consortium claim, minor child is on SSI and Medicaid, case settles, the minor's money goes into a special needs trust, mom and dad get $250,000 for the consortium claim. Even though the minor's money went into a special needs trust, you just disqualified the minor child by giving mom and dad 250 grand, because that money is deemed to the minor child as long as they're under the age of 18. Doesn't apply once the child reaches age of majority between parent and adult child, only parent and minor child. And that same deeming issue occurs between husband and wife. So you've got to be careful about the planning that you do and make sure that you don't undo what you've just done because of deeming. Now, there are many cases where a special needs trust may not make sense, either because it's too small of a settlement or the injury victim wants to spend the money to buy things. And there are certain things that you can buy that could be used as part of a spend down plan on exempt assets. And exempt assets, the primary ones are home, one vehicle, accessibility modifications to home vehicle, paying off debts, purchasing household items such as electronics or refrigerator, washer, dryer, appliances type things, clothing, anything that's in the house typically is not countable. But one thing that's important is spend down doesn't allow you just simply to gift the money away. And there are very specific timing and rules and reporting requirements that vary state to state if you're going to engage a spend down plan. So if you're going to go this route, it's typically advisable to consult with an elder law attorney in that state who's familiar with these state to state rules. And my background is in that area. I've got an LLM in elder law. So in Florida, I will work with clients and advise them about these specific issues. And you want to find an experienced practitioner in your area that understands these issues. One other alternative are ABLE accounts, although they're limited in their applications because of limits on what can be contributed. So typically, instead of being an alternative, it may be done in addition to a special needs trust. So with an ABLE account, the funds are not countable to the client, just like a special needs trust, but the client has control over how to spend the money. As long as they spend it on qualified disability expenses, which includes food and shelter, unlike with a special needs trust, they can remain eligible. The limitations are the client has to have been disabled prior to age 26 to set up an ABLE. That age limit is going up to 46 in 2026. Only the first 100,000 is exempt from being counted for SSI. So you can't have more than $100,000 in an ABLE account with someone that's on SSI. and you can only contribute $17,000 each year to an ABLE account. There's a little bit more allowed if the client is working. These do also have a Medicaid payback requirement. There are ABLE programs in every state, and some programs are available to out-of-state residents. So you can take a look around on the internet and find these different plans. And that's something that probably should be explored, particularly when you have a situation where food and shelter needs to be paid for out of the settlement monies. So turning now to those that are on both Medicaid and Medicare benefits. So remember, early on, I said that there is this category of dual eligibility, which means that the injury victim is eligible for Part A and or Part B as well as Medicaid. So what happens for these particular injury victims is that the Medicare program is primary, and Medicaid will pay the Medicare copays, deductibles, and Part D costs. So it can be a situation where there's basically no out-of-pocket because of this dual eligibility. The problem is that, and I talked briefly about Medicare set-asides, if an MSA is set up for someone that's on Medicaid and SSI, that's an available resource. So in many states, there are some exceptions to that. So again, you've got to go state to state. But the MSA, if it's going to be set up for someone that's dual eligible, must be inside of a special needs wrapper, which basically is just a special needs trust with Medicare set-aside language included. But these classes of clients really need that extra layer of planning to make sure that all their government benefits are preserved. And because they get so much in the way of government benefits, it really is an opportunity to make sure that that client gets every single dollar from the government, plus gets to use their settlement proceeds. So that's the end of the substantive presentation. I always end these presentations with this picture, one, because I'm so proud of the incredible team that we've got at Synergy, but two, because this team is one that's incredibly dedicated to our mission, which is improving the lives of the catastrophically injured and allowing trial lawyers to focus on what they do best. And every day we work incredibly hard to make sure that we deliver on those promises in our mission. And so this team is ready to assist trial lawyers and injury victims each day. And I'm thrilled to be a part of an incredible organization with a wonderful mission like we've got. Synergy can help with a variety of things, from healthcare lien resolution to Medicare compliance, government benefit preservation, settlement consulting, group projects, and attorney fee deferral options. If you have any questions about today's presentation, or if you'd like a copy of it, you can email me at jason@synergysettlements.com. My phone number is on the slide in case you ever want to reach me. A lot of what I talked about today is covered in some of the chapters in my book called Art of Settlement. If you'd like a free copy of the book, I am happy to send it to you. Just send me an email with Art of Settlement in the subject line, and include the address you would like a copy sent to, and I will send you a copy. So just email me if you want to take advantage of that offer. And if you want to learn more about Synergy, please call us or visit us on the web. Thank you for attending today's webinar.